All right, Ms. Adelson, I want to test your audio one more time. If you can tell me the name of your high school mascot.
It's been a few years. Oh my God. I cannot tell you. I don't remember my high school mascot.
These are the things that are burned into the brain, but anyway, is not why we're here. We can hear you now over the loudspeaker, so your video and your audio is working. All right, we're here today for a status before we get to, I believe, some of our cutoffs and also our deadlines. I'll allow both parties to be heard if the state wishes to go first.
State does not wish to be heard today. We're ready for the trial and intend to comply with the deadlines that the court gave. The defense and I did have one agreement about a deadline that they possibly wanted to push back by, I believe, 2 weeks. They had asked if they could push back the demonstrative exhibit deadline till September 4th. We don't have an issue with that. We believe we'll be able to comply with everything in the judge's order. The only Sergeant Corbett's presentation sometimes can take a little longer, as I know last time it changed a couple of times before trial, just minor changes that he made. We were able to keep defense up to speed with that and had agreements as to that. We've talked about that and intend to do the same thing this time if we could have the deadline of September 4th for our demonstrative exhibits. We can give him a pretty finalized rough draft of that by that point, and any minor changes that do need to be made, talk to the defense about that after that time.
All right. If the defense can explain why you would like this to be pushed back, and the only reason I ask this question is because once everything is filed pursuant to the deadlines, we need to have probably at least a 2 or 3 hour hearing on all pretrial motions, so I don't want the start of the trial to be bogged down by needing a ruling on a particular issue or motion, but I'll allow you to explain.
Judge, I think the construction of some of the demonstratives, obviously I'm new to the game, so to speak, but in this case it is a different case factually from those that have been tried before. But just the construction of them and meshing them with electronics that we're going to have available, I would just like, we've gotten some new discovery in recently as well. That is going to be incorporated into our demonstrative, so it's just a little bit more breathing room to be able to get it done.
And I assume both sides are going to want the headsets and the various audio media aspects for the jury once again?
Yes, sir.
Yes, sir.
Very well. Then going back to the order setting the procedure dates and also the deadlines as far as any demonstrative exhibits, then I will permit both sides to have until September 4th to ensure all demonstrative exhibits are traded between the two parties. As far as the witness list and the exhibit list itself, there's really no reason why August 12th that cannot be met, correct?
That's fine, Judge.
That's correct, and we would like it to be so and maintained. Likewise, Judge, we do have an agreement with Ms. Kappelman with respect to some of the exhibits and the manner in which they're listed. By way of example, Donna Adelson emails, but it won't be more specific than that in the prior listings that have occurred. And so we've talked to Ms. Kappelman about them being more specific when they're listed, with the understanding and the caveat that that would be a rolling list that could be supplemented, the exhibits could be supplemented. It's just to bring focus to, rather than digging through 50 hours of recordings or 5,000 emails to draw everything in focus. So you don't need to do anything on that. That's what our agreement is. But on our August 12th deadline would remain the same for everything with the exception of the demonstratives.
All right. Do we need to address the modification to the trial date any further as to September 17th being the first day of selection?
No, sir.
All right. Time-wise, I would expect we're probably going to be similar to the last trial where we have at least 3 days or 4 days of selection. Assuming we are successful, we would get started, and then we would have about a week or maybe a week plus of trial. Do the parties have a differing expectation of this?
We sketched out the number of witnesses, and some of it will be more focused once we get to August 12th, but I had some concern based on the volume of witnesses that we had agreed on. We were solid 2, if not more.
Well, good thing I help everyone along in this process.
And now that may drastically contract, because there are several of the witnesses that are very, very short, and there are simple things that we may even arrive at stipulations to knock those things out of the way. But I would be leery of telling you that it would all fall within the confines of 1 week. I feel like 2 weeks we could push hard for.
Okay. Well, you have until August 12th, I should say, to iron out aspects of this. Ms. Dugan, at least preemptively, would you expect the state's case to last for about a week once again?
Yes, sir. And I think last time, or the last 2 times, we have been able to pick a jury in 2 or 3 days, and the state's case took about 5 days. I would expect for it to be about the same.
Very well. Are there any other issues that either party needs to raise for the status as of today?
Judge, we're going to be filing several motions, some of which you've never heard before, and some of them are going to deal with, for instance, just so the other side knows, we are going to move to preclude Sergeant Corbett's testimony, which will obviously affect the demonstratives, but we think we can do that even without seeing the exhibit. But one of the motions that we intend on filing, I just want to let the court know of beforehand because it might affect scheduling of courtrooms. We're going to ask that the trial not be in this courtroom.
For 3G?
What's that?
For this courtroom, 3G?
Yes, we're going to ask that the trial be held in your courtroom 3B. And we have a variety of reasons why we think that courtroom will afford our client better due process than this courtroom does. And so we're filing that motion, and we'll file it on time. But I just want to give you a heads up so that if there's a scheduling issue, you're aware that motion is going to come down the road.
Very well. Really, until I see the motion and the state makes its argument, I won't be able to make a ruling on it, and that'll happen in time. As far as selection itself, though, we may still need to use this courtroom just to hold the sheer volume of prospective jurors that are needed, but as to the courtroom the trial will occur in, that certainly we can address with the motion.
And the motion, I should have said that, the motion contemplates that jury selection would still be.
Right. Ms. Dugan, any additional matters the state needs to address for today's hearing?
No, sir.
Very well. To go back to the scheduling order, our next set of deadlines will be discovery on August 12th, the motion filing deadline August 12th, the witness list and exhibit list also on August 12th. And I believe our pretrial hearing, not referring to the motion hearings that will be filed, but just the final pretrial will be September 12th at 9 o'clock. Mr. Morris? With
the advent of some of the new discovery, we're endeavoring to take a few depositions. We've worked with Ms. Kaplan and also Ms. Dugan to be able to coordinate this by Zoom if necessary because of travel and things of that nature. The reason I bring it up, there's probably a chance that there are depo dates that are going to be after the August 12th date, but they will be set and noticed at that point. I hope that will be set, noticed, meets the deadline, hopefully, so this doesn't become a similar issue like it did last time. If we need to address a particular aspect of discovery that needs to occur possibly after the 12th, go ahead and move in advance for that so it does not become an issue of anyone violating the deadline or attempting to take or seek discovery after the deadline is passed. Okay? All right, with that being said, this status is coming to an end unless anyone has anything else you need to bring to my attention.
Nothing, sir.
All right. Ms. Adelson, were you able to listen and follow along to my discussion with the attorneys?
I could hear you, I could hear nothing that the attorneys were saying.
All right. I really can't ask them to repeat themselves in full, but your counsel have asked to set back one of the deadlines to September 4th. I have agreed to do that concerning demonstrative exhibits. All other deadlines are going to remain in place. They will speak with you concerning any other issues that you need to discuss with them about today's status, okay?
Okay, thank you.
All right, we are in recess. Have a good day, everyone.